Here is, Your Honor. First, we are proceeding on the temporary relief component of the motion, primarily to bring ourselves in alignment with the other litigation in other counties and what had transpired in the 5th District. So we'll be proceeding on the temporary 11-101 on this date, the interlocutory. The 5th District, in the recent case earlier on Wednesday, has resolved essentially counts 1, 2, 3, and 4 of our pending action. Counts 1 and 2, the TRO would be denied. Count 3 denied. Count 4, the TRO would be allowed on equal protection grounds. I won't belabor much argument unless the court seeks it on those points. In our memoranda, we've acknowledged that for purposes of the interlocutory proceedings on the temporary restraining order, that the 5th District's invited the Supreme Court to revisit, we would not have a fair prospect for success on the merits based on the existing law on counts 1 and 2. On count 4, the 5th District, in a pleading nearly identical, and I should say wholly inclusive of what we say, we add some things, found that the legislation, the Public Act, violated equal protection because it denied some similarly situated the equal protection of the laws within the legislative scheme. Go on arguing on that point, but I believe that we recognize that the 5th District has faced the issue squarely, issued the restraining order temporarily on that basis. What we would add is that at count 5 of our complaint, we raise an additional basis for the issuance of injunction, and this being the proscription against special legislation at Article 4, Section 13 of the Illinois Constitution. Special legislation is like basically the twin sister of equal protection. They're very similar. They're not necessarily coterminous. In fact, as applied to this case, I believe that a facial attack, which is what occurred, we submit on equal protection grounds to present the legal entitlement to injunction in the 5th District, but that a facial attack is better informed even under special legislation. And assuming the court's read our briefing, I won't belabor many of the points. The special legislation looks at the scheme to determine whether the legislature's created benefit, privilege, or immunities for some that they have not accorded to others similarly situated. So we can start. Unfortunately, our legislation, as the 5th District noted, has really no clear statement of state interest that informed or justified the enactment of the legislation. The swiftness with which it was enacted and the absence of any legislative history to truly identify the state interest being represented causes a little difficulty in determining class similarity, and that's been noted in the 5th District, but not sufficient to defeat or to reject a finding that a fair question has been presented. However, I believe that we point out issues that were not more deeply or fully vetted in the Effingham or the 5th District case regarding special legislation. And it starts, if we view that the Second Amendment right is a right shared by a similar class of FOID card holders, able-bodied citizens, for which there is constitutional grounds to define that class, that the legislative scheme starts creating special privilege and immunity within that scheme. It first starts on a very basic level by who they grandfather in and who they will prohibit entirely the opportunity to possess, access an assault weapon per their definition. And that's before you even look at the 7 categories of specially benefited. We have just the class of all FOID card holders. If you owned a gun at the time of enactment, you can effectively register it and keep it. However, if you were equally skilled or could be equally trained in the use of an assault weapon and desired to buy it one day afterwards, you cannot have it. You cannot register and have it. You cannot, or the endorsement affidavit they call, and have it. So right then and there, in the class of all Second Amendment right holders, all FOID card holders, we've created a class that has no bearing on training or safety. No nexus whatsoever to that. Rather, you get to keep it under certain conditions, and if you are equally skilled, equally capable of being trained to have it, you cannot, on the mere fortuity of date of acquisition or date you desire to acquire it. Also, the scheme, even amongst that class, will impact the means by which you can acquire it if you've already had it, and put you in a special category for how you can alienate the weapon, or the gun, trade, sell, transfer. So we have that patchwork of classification. We then apply the accepted categories. And this quilt of patchy regulation becomes quite a colorful mosaic in determining who can have rights compared to others. They define the classes. We presume, though, I would note that at this stage of the litigation, there is no legislative history or basis for a strict scrutiny analysis to provide any basis for the court to justify these classifications. But even if we presume it is on safety grounds, it is not a general law. And in special legislation, we're looking, are we creating special categories, or can a general law, and under strict scrutiny, a general law that is most restrictive or least restrictive, most narrowly tailored, is what would be required. Now, not for a moment do I contend they could ever regulate assault weapons, but that's not within the contours of this case don't address that. But can they create classifications as to who can have those assault weapons amongst FOID card holders? And we submit that that's where it starts to run afoul of special legislation. Even within each of the subcategories, which again are noted in illustrations in our pleading. Not being derisive in any manner, but we try to illustrate the problems comparing a security officer, the Paul Blart reference, to police officers generally. There is nothing amongst either of them that would indicate that one is more appropriately trained or higher qualified to collect weapons or engage in weapons commerce compared to others. But these classifications are set forth. He may use it at his work, perhaps, but how does he, the security guard, how does he not run into violation every time he goes home from his work shift? So that's, again, in special legislation, we ask, is there and this is the Grassi case that I cited in my brief, is that if the resulting legislative scheme has a mosaic, or I think they say a patchy quilt work of categories, one person impacted, another person benefited, another person altogether prohibited, you have special legislation. And the illustrations could abound. 4 or 5 of them were in our submissions to illustrate how this is occurring. The interesting thing in Article 4, Section 13, which is different from any other provision at issue in this case, is that it expressly reposes in the court the obligation to determine whether the legislation is special or whether it is general. An example of a general regulation, which I would fight as well, but for purposes of our analysis, a general regulation would say all assault weapons are subject to the endorsement affidavit. There are no winners or losers picked, no immunities to some, no privileges to a few, but rather every able-bodied Ford card holder would have to register the weapon. And if the legislative purpose was to trace or identify who had the weapons and where they were, you have a general law that serves a state interest that would solve the problem without creating the special categories. That is the easiest, I submit, and most obvious indicia of the special legislation. Now, for the sake of my clients, they would hang me if I did not say we would fight any registration law, but for the purposes of what we're litigating here today, that is an example of general legislation that would not, on special legislation grounds, be subject to attack. Another general law is that if what we're dealing with is the perceived danger of assault weapons, and you are committed to allowing some to have them and others not, you have to have, to avoid it being special legislation, a pathway to those that are excluded to exhibit or prove their training to handle the firearm, to use it safely, to possess it. The 5th District effectively notes this in its opinion issued this week in the accuracy firearms case. And in this regard, similar perhaps to concealed carry law, is that if you have training, you can have access to this particular classification of weapon. Now, that is a general law. It is not special legislation. A police experience might be something that could be exhibited as the equivalent of the training, but it would not be the police experience that is the trigger for the right to possess. Everyone would have the ability to possess the firearm. Some may have to take a class, the other on their experience could prove the equivalency of that training, but they'd be equally treated as the training. And it would not be, as this legislation operates to be, an entire prohibition to the ability to access, use, and possess firearms that others would be entitled to. Just another example of the application of Article 4, Section 13 on special legislation grounds. This is before we even get to the economic side of the regulation, is that the privileged, benefited, or what I would say probably the immunized class from the criminal liability, they have a broader ability to obtain the assault weapons because they are permitted transferees. They could collect, accumulate, take it out of state, sell it, profit from it. And in Best v. Taylor, which is cited, going back before the 1970 Constitution, the discourse was we cannot engage the habit of creating economic franchise in favor of benefited or privileged classes, which in a sense is what this does. All of those, any one of which standing alone, is an example of special legislation, and our determination that we seek, both as an incident of the relief for temporary restraining order, is that on its face, the legislative scheme constitutes special legislation. The significance, and again I underscore because I know this will be probably a greater point of our debate today, is that the 5th District opinion in determining that there is a fair question as to success on the merits, made that determination based on a facial analysis of the statute, a facial attack. And the Blagojevich case that is cited in our brief, which I think is most instructive, Morfitz, Inc. v. Blagojevich. In dealing with a First Amendment challenge, states that when we are attacking, and this is what we are as plaintiffs, alleged, and what we're attacking, is a facial attack on the legislation. And I'm going to discuss in the context of equal protection and special legislation, which would void the enactment in its entirety and in all applications. What we have going on in the state of Illinois right now, I think, is a mistake in the understanding of injunctive relief. If the attack is facial, as the Blagojevich case says, that the scope and force of the injunctive protection is in all applications. It is not just parties to the suit. If that were the case, do we have to await millions of lawsuits, millions of parties in the state of Illinois to have that adjudication? A cursory review of constitutional analysis exhibits time and again that constitutional declarations often occur through associations, representing members, but securing a declaration that has impact across the board. If Your Honor determines that, which I believe the 5th District's already determined, which I say is controlling precedent for this order, but also under the special legislation, that this facial attack that we presented a likelihood of success on the merits or a fair question of success on the merits, that the status quo requires that the enactment be voided in all applications, protecting all citizens in the state of Illinois until a final order, be it in this case, be it in these cases as I wholly imagine ultimately will be consolidated as they move through the system, but not to create a scenario where there is again, a patchwork of enforcement and the recurrent uncertainty as to whether someone is protected or not. Because the common thread in each of these lawsuits is that there is the finding that the legislation violates equal protection and special legislation. The special general legislation is not an applied for challenge or as applied challenge. It's on its face. So it would not be consistent with Blagojevich, nor is it consistent with the practical impact of the injunction. Consider 11-101 of the Code of Civil Procedure, the Injunctions Act, expressly states that the parties to the litigation are bound to the restraint. Here, that's the defendants, their employees, their agents, their attorneys, and anyone acting or participating in concert with them. Effectively, that captures the state of Illinois already with respect to the 5th District case. And we submit it would catch them in this case. I am not bound in one aspect for what's happened in the 5th District. The litigation decision of the plaintiffs in the 5th District, for numerosity of plaintiffs, for whatever economic reason they may have had to represent that group in that manner, as opposed to proceeding in an associational approach, does not bind me. The fact that they sought a restraining order in Effingham County only to protect the plaintiffs does not diminish the fact that the legal declaration is that the statute facially violated equal protection. It does not limit me to advocating the restrictions that the Blagojevich case dictates apply, which is that it would void the enactment until further order, as any temporary interlocutory proceeding would, in all applications. You've read the motion to intervene. I'm here on a lodestar being paid by the hour, not a per litigant fee. So it is, this litigation is designed to get to the declaration, the pleadings, to get to the declaration and the relief we request, to get to the declaration, which is a component of the injunctive relief, that this legislation, I've now got two grounds, equal protection and special legislation. Because we have a lot of confusion in the state of Illinois. Who's protected by the order in Effingham County? Well, I know on the face of the order, because they only sought protection for the named plaintiffs, perhaps only them. I read the 5th District opinion and see that it is a facial attack, and they have declared it a fair question that there is an unconstitutional violation of equal protection. I submit already the state of Illinois is protected from enforcement, and not just the named plaintiffs. The Injunctions Act and the case law that is cited in the brief received last night from the state of Illinois is dealing with the scope of people who are actually named defendants. The respondents have to be actually named, or they can't be bound. If I want an order against someone, the order has to name them. Or if there's someone acting in concert, they have to have actual notice of the order. I have identity of party such that they'd always be collaterally estopped from ever enforcing it. For them to say, well, they don't have res judicata, doesn't understand the binding impact of that order. It's interlocutory, and it would only last as long as a court keeps it in force. But it is still an order that would be operable as to all applications. Statute, I think, it makes it clear that it will be binding and not available only to the plaintiffs to enforce. And likewise, when they have a order declaring it violative of equal protection to enforce the public act, and they send somebody out to enforce it, quite readily, as long as accuracy firearms is viable, any proceeding pursued would be dismissed on the basis of that opinion. And quite problematic for the state actor if they would try to enforce with knowledge of this order, and what I'd submit would be violation of this order. They'll have a 1983 violation and will be defendants in a lawsuit. So ultimately, there's the practical backdrop that is consistent with avoiding the enactment temporarily in all applications. We're already in the state of Illinois where over 75% of the sheriffs say that they won't enforce it. We have county courts saying that they find it unconstitutional. We have a 5th District Appellate Court opinion declaring it unconstitutional on equal protection grounds. We have chaos right now, and we need to have an order that is clear that this application, that these orders already entered by the 5th District and in this proceeding makes it applicable in all applications. Count 7 of my complaint is a due process, what we call the trapped plaintiff, and it is, in this instance, as applied, but it would be temporarily a moot question because under count 4, the statute should be suspended and enjoined from enforcement pursuant to the Equal Protection Clause. So I think that reaching that as applied follows is not right, while the declaration is that it is facially unconstitutional, that that as applied issue need not be addressed in this interlocutory relief. We don't waive it. It's out there. The point is that because of what we would refer to as Governor Pritzker's midnight run to the General Assembly, people with executory agreements, vested rights in contracts, overnight found themselves engaged in a transaction that was now unlawful. You have customers that couldn't get their guns back that they had pawned in conformance with the security agreement with the pawn shop. So they had no opportunity to do anything. And in this respect, counts 2 and 3 infect the due process challenge we raise at count 7 on an applied as applied.
Thank you, Your Honor. So this is actually the third TRO hearing that I have attended and argued at regarding the Public Act 102-1116. I was in Effingham County 2 weeks ago, White County last week. I thought maybe the third time would be the charm here today, but then on Tuesday of this week, the 5th District came out with its opinion in accuracy firearms. And as you know, and as Mr. Stocks said to you as well, accuracy firearms is binding on this court with respect to the request for a temporary injunction as to the equal protection. Additional counts in the complaint here today. The special legislation count, which we heard a lot about today, our view is that's governed by the same standard as the equal protection count. So there's no need for me to respond to those arguments. We are bound by the 5th District's holding in accuracy firearms, so I don't think I want to waste your time on that. As to the other new count, which was the due process regulatory takings count, as Mr. Stocks said, they are not seeking a temporary restraining order on that count, so I won't speak to it either, but you can see Then the other big difference between this case and accuracy firearms is that in the motion, which was filed, I believe on Monday, correct? Originally, Mr. Stocks and plaintiffs sought a declaration to be entered today. And as he's mentioned, he's no longer seeking that today. We'll set a briefing schedule and we'll deal with that down the road. So that leaves just one point for me to address with the court. One point of disagreement that we'd like you to resolve here today. And that is the scope of the temporary restraining order that is being entered. I think this is very important, Your Honor, that in the motion, which was filed on Monday, in the prayer for relief, and this is on pages 4 through 5 of that motion, it's paragraph B, and it seeks a temporary and preliminary injunction, I assume that's a temporary restraining order, enjoining defendants, anyone under our control, from exercising any color of authority to enforce the 2 core criminal law code amendments that were in against plaintiffs. So in their request for relief in the motion, Your Honor, they only sought a TRO prohibiting the defendants from enforcing against plaintiffs. The first time I heard, or anyone heard, that they were seeking a TRO preventing enforcement against everyone in the whole state was yesterday around 2:30 when they filed not a response to anything that the defendants had done, but rather Mr. DeVore's petition to intervene in the action. And then all of a sudden it appeared that they were seeking a much, much broader TRO than what they sought in the motion. So obviously that's procedurally improper, Your Honor. But as to the authority for you to do it, it simply doesn't exist. I want to be clear about this. As to the 3 named plaintiffs, the 2 individuals and the business, of course you're authorized and in perhaps required by accuracy firearms to enter a TRO as to the 3 of them. As to the voluntary association, Your Honor, in concept, we haven't objected to the notion of a TRO preventing enforcement either as to the association or its members. The only objection we've raised is that as a practical matter, Mr. Stock said in his response filed yesterday that we just don't know who the members are at any given point in time, which makes it extremely impossible to know who the act can be enforced against. If there was some way to clear that up, I wouldn't have an objection to the TRO being entered as to them. The objection is only as to the entire state of Illinois. The only authority that's been cited to you for that proposition is that it was cited for the first time in a motion, a response filed sometime this morning. I got it on the way down here. My understanding of the Blagojevich case, Your Honor, is that it has nothing to do with the scope of the convention. The line that was read from it about a facial challenge is correct in two respects. So a facial challenge attacks the constitutionality of the act in all of its applications. I believe probably all, with the exception of count 7, probably all of these counts are facial attacks. But what the Blagojevich court said was not that a court can therefore issue a temporary injunction on any facial challenge. It applies across the entire state. What it said is that once the Supreme Court declares that a statute is unconstitutional on a facial basis, at that point, statute is void. Not before, not the scope of a temporary injunction. Simply when the Supreme Court has finally declared that a statute is unconstitutional on a facial basis, it is void in all applications. That does not support the request for relief that's been asked for here today, Your Honor. And Mr. Stocks mentioned too that Mr. DeVore, in his two cases, the one in Effingham County and the one in White County, had done it a little bit differently. He only asked for relief in those cases on behalf of his own plaintiff. I've known Mr. DeVore for a while, and I was involved in the first Bailey versus Fisker litigation down in Clay County about 3 years ago, relating to the scope of the governor's COVID-19 executive order. And in that Bailey litigation back in 2020, Mr. DeVore did the same thing that Mr. Stocks is doing here today. He asked for an injunction to be entered as to the entire state. And the judge, Judge McKinney, who is now Justice McKinney, denied him that relief. That's the reason why Mr. DeVore has only asked for an injunction to be entered as to the plaintiff. But we lost on the substance of many of those TRO motions, rather. We won on that point. A TRO can only issue as to the main plaintiff.
Here on a TRO with notice and their opportunity to argue, so it's the issues raised here today that will dictate what is necessarily what was in a motion, especially one before the 5th District opinion. Secondly, we do have in the pleadings and argument before the court Exhibit A to the complaint, so 650. Purposes of the facts upon which the temporary relief is granted, they are the association. That is the allegation to the complaint. So it's, there's no motion to strike that, to eliminate that. There's nothing that would support that relief other than Tom DeVore's motion to intervene on behalf of a person that was individually listed in an individual capacity. So the legal force of Exhibit A on behalf of the association, which under Easel and the Cook County case that we cited, the association does have standing to vindicate those rights. Still, I would note on the Blagojevich case, that was on a motion to dismiss a complaint for temporary and preliminary injunction raised to assert a facial attack on the First Amendment. Trial court dismissed the complaint seeking that relief. When it got to the Illinois Supreme Court, they said this is a facial attack based on the First Amendment. Sent it back, reversing the trial court's dismissal. So it's not foreign to the circumstances facing us here. I respectfully submit that it does provide that if equal protection or special legislation. that that trial court for not moving forward on the injunctive relief was reversed by the Illinois Supreme Court. So, in response, if the order for injunction finds, as I submit the 5th District did, that the legislation violates the Constitution facially, operation of law, and the holding of Blagojevich, that is void in all applications. And submit that. That's the scope that should be applied. Minimally, there is no basis to disregard the incorporated consideration. We've briefed what an association can represent, and I don't know that they quarrel with the notion that members likewise can be protected, but it should not in any respect be limited.
Thank you. And just one point. Mr. Stuck said that the 5th District found that the legislation violated the Constitution. That is not correct. The 5th District found that the plaintiffs fair chance of likelihood of success on the merits of their claims that the legislation violated. Far cry from a finding that the Constitution has been violated. And as to Exhibit A of the complaint, Your Honor, I'm quoting from the response that plaintiffs filed yesterday to Mr. DeVore's petition. They said, quote, "It is likely that members of the association, quote, will be in flux as no obligation binds them to stay or denies others joinder." That's the 3rd page of their response at paragraph A. In that same paragraph, they offered that the court might want to strike Exhibit A. So I don't know what the status of Exhibit A is at this time. I don't know if it lists the members or not. I don't even know